some of those stocks are concerned. But tell you what, the Insolvency and Bankruptcy Code Amendment Bill 2025 is something that we should also be looking at, because that's the one that proposes several sweeping changes to streamline the insolvency resolution process, also improve clarity for stakeholders and enhance asset value recovery. In fact, Shrimi is joining in with all of those important details there.
Yeah, so clearly, actually, 5 big amendments in the proposed IBC bill introduced by Finance Minister Nirmala Sitharaman on Tuesday, and I will take you through to the 5 important amendments in the IBC bill, which will be taken up possibly in the next, parliamentary session, that is winter session. So first up is that this IBC bill is clearly empowering Committee of Creditors. So 2 important amendments this bill is proposing. One is that it introduces the flexibility for out-of-court settlement led by the corporate debtor under COC oversight, is something which reduced lot of litigations and will do a lot of out-of-court settlement, and this also empowers COC clearly to play a more proactive role in the resolving all the asset stress and the issues in the resolution process. The second important power with COC being given in the IBC bill is that now COC of a holding company can enforce guarantee given by its subsidiary companies. So far at present, there is no such provision where a COC of a holding company can actually have access to the assets of the subsidiary company, but here the bill is proposing that, and this also means that they can have access to all the guarantees given by both corporates and personal guarantors. That will come under their purview. And in fact, this will clearly eases and streamline the entire resolution process for corporate and entities. And in fact, it will become a more attractive for the potential bidder, as because whomsoever is interested in the main holding company would like to also have assets of the subsidiary company, for example, land, etc. So that will become a more attractive bid for any potential bidder in that interested in that insolvent company. The third important is that shifting the CCI approval after COC actually voting on that resolution plan. So far all the potential applicants supposed to take CCI approval on a resolution plan before the credit of committee approval. But what IBC is saying now, that you can actually go forward with the COC approval first, and then perhaps you take a CCI, Competition Commission of India approval, and that is saving a lot of time for all the bidders, because now only a successful bidder actually will need CCI approval on the resolution plan. Now, fourth important, on the clarification on the secured creditor. Now, this is also has been a very pain point in the whole resolution process. What happened here is that only creditor with contractual security interest will be treated as secured creditor. So far, any statutory creditor, for example, tax department, VAT department, any state department, used to have, used to give that we should be also giving priority in terms of securing that asset in the resolution process. But what IBC proposing here is that you need to have a contractual agreement and the arrangement with the debtor to secure that, rights on that asset resolution, is something will clear the lot of confusion and ambiguity in the whole process. The fifth and important here again is the mandatory admission by the NCLT. Now, the NCLT IBC proposing that it must admit the insolvency application if a default is established. So far, what is happening here is that NCLT has a lot of underlying condition to actually admit any insolvency, cases, and that was delaying the whole resolution process. So what the bill is proposing, that if you need to just see whether the default is there or not and just admit the case. So clearly, it's also kind of reducing the discretionary power of NCLT, but in the flip side, it will, also reduce the whole timeline of the resolution process. So this is what the 5 key takeaways of the amendment is, what I see.
Well, absolutely. Thanks, Shrimi, for joining us with all of those important updates. So not one, not two, but 5 big changes that Shrimi's just talked about. In fact, let's take that conversation forward and get experts on board, discuss this with them as well, because we do have Sonam Chandwani, who's the managing partner at KS Legal and Associates, joining us, as well as Kumar Saurabh Singh, partner at Khaitan and Company. Thank you so much for taking time out this afternoon and helping us out with this. First things first, Sonam, I wanted to come to you and I wanted your take on this as well. Do these amendments, according to you, signal a shift towards a more creditor-driven insolvency regime? What do you make of this then?
Yeah, I mean, it clearly strengthens the lower role of creditors in insolvency proceedings. So it allows creditors to, start resolution process outside court and gives the COC authority to replace liquidators or, also pursue group assets. So this definitely reduces delays, which currently average around 434 days for case admission. And also it ensures faster recoveries. While this empowers, banks and financial institutions, it may also limit the influencers of smaller stakeholders. So this amendment definitely aligns with India's insolvency framework with global standards, enhancing efficiency and greater confidence overall.
Saurabh, I would like to come to you, Shrimi, here. I wanted to ask that this corporate-led resolution framework, which is the part of the proposed bill, do you think that it involves a risk in terms of it's taking you towards pre-IBC, culture, the informal culture, and that will also lead to prolonged restructuring? What's your take on that?
So, Shireen, I think corporate-led resolution is something which is now being introduced after experience of last 10 years. So now if you see in last 10 years, IBC has built very robust framework for strengthening the hands of the creditors. But what we have also seen in the process is that sometimes the initial opportunity not being available with the company can lead to actually deterioration in value of the assets, and therefore a effort to revive the company through a framework which is having blessing under the code will really give a balanced framework to the code, really, where the first shot at resolution is allowed to the incumbent. But if that doesn't work out, then the creditor-led process takes shape. And if you see, even from more experienced jurisdictions also, the opportunity given to incumbent is not shunned upon. But in our case, if you see, that framework was largely coming from RBI frameworks, did not have wider recognition in the court. So I don't see it negatively. It's only trying to create balance in a time-bound manner. And if it doesn't work, then surely creditors can take charge and run the resolution process thereafter.
Sonam, I would like to come to you as the bill, clearly say, indicating towards that it's limiting the power of NCLT. Do you think that it will, help fast track the whole resolution process? And because now what the bill is suggesting that you have to just establish whether default is there or not and admit the case. So do you think that it will change the whole IBC process and reduce the timelines?
Yeah, it definitely will. Of course, I mean, so by mandating NCLT to admit applications within 14 days upon proof of default will definitely push the timelines. It is also supported by objective evidence like information utility records. The amendment also eliminates subjective grounds for rejection that currently prolong admissions to an average of 434 days. So this also ensures, swift initiation of proceedings, preserving asset value, and also elevating the strain on overburdened tribunals. So it may also argue that, this curbs judicial flexibility to filter frivolous claims. The clarity and speed it introduces far outweigh such concerns, fostering predictability for creditors. The reform also aligns with the IBC's core objective of time-bound resolution, reinforcing India's position as creditor-friendly jurisdiction. So this change for enhancing efficiency while urging robust safeguards to prevent misuse will definitely, push the timelines.
Mm-hmm. Mm-hmm. But sort of on the part of the whole which department to get actually priority on the assets. the whole clarification which impacting the ongoing, how they're going to impact the ongoing litigation in that case, how those will be get affected. For example, tax department has, certain, say in that asset. And then, of course, the financial creditor, the difference between operational creditor and the secure creditor as clearly attempted to be defined in the bill. So how that is going to impact, don't you think that then tax department and other department or statutory department will take a back seat?
I think the amendments were imminently required. If you see last 2-3 years, the number of litigations that has happened from tax and other government departments, I think that is taking us little bit away from the whole objective of insolvency, which was the creditor in control and creditor driven process, where the financial creditors who have really lent for business, they run the resolution process and they have first right of recovery. So you kept the shareholders out of the process, board out of the process, and with a view to enhance recovery for the creditors who have lent for the business. Now, as far as the tax department is concerned, if you see the original scheme of the code, it was really championed as a code where secured creditors are being given priority above all else. It was only through an interpretation which was made by Supreme Court that secured creditors included government claimants also. That was not the original idea. It just required a technical interpretation to bring tax department at par, and that can really affect decision making, because tax department doesn't sit in the COC. Every time a resolution is approved by secured creditors, tax department can have a different view. And when you had come up with a code which puts financial creditors above all else, why dilute it through this kind of technical interpretation? But be that as it may, that happened through a order from court, and now I think this clarification that government dues will come down and the security interest is only contractual security interest is a move in the right direction. I think the Supreme Court judgment was really not helping the entire clarity which was required around resolution process. So tax department clearly is not intended to be a critical stakeholder in decision making in resolution process, and if you put them right at the top, it's very likely that their position will come in conflict and it will lead to more litigation. So this clarity on distribution was much required, and they were from very beginning required to be lower in priority than secured creditors. And I think secured and financial creditors being above then government dues is the stated position with which government had introduced this law, and this clarification really removes the ambiguity which had got introduced through Supreme Court order. So in that sense, it's a very welcome move as far as we see the entire scheme of insolvency resolution.
Saurabh, just a clarity needed that will that have a bearing on the ongoing cases? And also I wanted to understand that this overhaul in the IBC framework, does that have any impact on the JSW Bhushan Steel matter?
So you see, the clarity, this is still at the bill stage. This proposed changes is at bill stage. It will go to the select committee of parliament and then will come for lawmaking in due course. But these are a lot of amendments that have been introduced are really trying to address say indifferent interpretations which have come from our courts, which tends to happen. I mean, in a system that we have of multiple courts and multiple states having judicial administration looking at situations differently, there is possibility of conflicting interpretations, and I think there was much needed requirement to bring about clarity. In the same spirit, Bhushan Steel also, I mean, while that matter is in Supreme Court and the courts are already addressing the original order which required company to go into liquidation, but I think this issue also gets clarity through the amendments proposed, that if provisions of the plan is not in compliance with law, NCLT should send the matter back to COC to reconsider and get the issues addressed, rather than the path which has been taken currently in Bhushan Power and Steel matter to put company into liquidation post approval. I think that may have far-reaching impact, and that we are already seeing how it is playing out in Supreme Court. So I see that the amendments are all very timely and should be very promptly implemented. And some of the issues in Bhushan will also get addressed, and we'll not see future Bhushan Steel kind of situations if the law is correctly introduced and implemented by way of amendments which are currently proposed.
We'll see how things will pan out, because now the bill has been referred to Select Panel Committee, and they will come out with their own recommendation on that. Thank you so much, Saurabh and Sonam, and Shanshi, over to you.
Well, absolutely. Thanks, Srini. That was quite a detailed look into that particular story. So that's something that you should be keeping on your radar. But tell you what, let's also keep Premier Explosives on our radar, because that's